Hi everyone, this is Disability Attorney Andrew November, and thank you for watching Andrew's Answers. I want to answer a question that I'm getting more frequently over the past year or two, and that is, why is my case taking so long? Well, that's a good question, and you're probably familiar with the word ERISA that I use a lot, and ERISA is the set of laws that govern the administration of disability policies when they're obtained from past employment, which is the vast majority of my clients, because you, the person watching this, probably got a policy as a benefit of your employment. Maybe it was called a fringe benefit, or something to entice you to work, and it's a short-term or long-term disability policy. So if it originated from your job, unless there's some nuances that we can look at, it's probably going to be governed by ERISA. And the reason why I'm bringing that up and talking about it in so much depth right now is because once we know ERISA applies, we know that there's specific policies and procedures that are going to guide how your case is going to play out. So what is making cases take so long lately? Well, in 2016, the ERISA regulations were updated. And without going into a long video about administrative law and how regulations are updated, suffice to say, the regulations changed. And one thing they did was they came up with something that, I don't believe it's called this in the regulations, but the insurance companies tend to call a review and response period. Here at my office, we call it a proffer and response period. And the reason why we call it a proffer and response is basically, in plain English, once you file your appeal, the insurance company is going to go out and get a medical review. Hopefully the review indicates that you're unable to return to your job and thus you're disabled as your policy defines, but more often than not, they're going to find a doctor, whether one that works for the insurance company or one they pay a flat rate to say that you're not disabled. Now, under those new regulations, they must proffer, that is, give a copy of that to you or your representative to comment on it, hence review and respond. Now, when these regulations first came out, I'll admit, I was jubilant about it. I was really excited. I was like, oh, this is great. And sometimes it is helpful. Sometimes if we have a medical opinion and it's just so out there, I can go to your doctor and get a rebuttal, or I can just write a rebuttal myself. But a lot of times it's not great, because what it's doing is giving the insurance company unlimited bites at the apple on their end. So I always talk about us getting more bites at the apple. But basically what I've noticed, the way these regulations are being utilized by the insurance company, is that every time you respond to the insurance company or submit something, you're just risking another piece of unfavorable evidence getting added to your file. So I've identified two problems so far in this Andrew's answer. One, this just takes time. So every time they give you an opinion to address, that's adding time outside of those 45 days appeal windows that we've talked about many times. That's problem one. Problem two is, it gets really hard to litigate your case when the insurance company has 5 medical opinions that are against your claim. So right now, me, my colleagues here, as well as colleagues out of the office that I talk to on a regular basis, are trying to strategize to how to deal with what I like to call it is whack-a-mole. Basically, the insurance company is forcing you and your lawyer to engage in proffer whack-a-mole. So every time you submit something, every time you respond, another opinion that you've got to whack out of the picture. It's becoming a big problem, so we're working on it. I haven't seen a lot of cases litigated on this, and when does the appeal period stop? When should you be stopped from having to chase all these moles down? The case has to end at some point. You have to be able to sue at some point. So we make this answer just to let you know that we're aware of this, we're watching this, we're workshopping different ideas, and we will protect you. But that is why cases are taking longer. And, we want to hear about your issues. So if you're trying to do this on your own and you've been proffered some evidence, be careful about responding. Let us take a look at it first, and we can respond for you. Thank you for watching.